right, we got a couple more people trickled in. Hopefully, we'll get a few more as we get going. Um, just so welcome everyone to our January Fired Up Fridays webinar. Uh, my name is Kim Hunsinger. I am the litigation specialist at Employer Lawyer, and our topic today is going to be what happens in a lawsuit, a clear practical guide for business owners. It's just little logistics to get started. If you have any questions, feel free to pop them in the chat. Michelle, she's our assistant. She'll be helping field those so that we can get all your questions answered as we go. And there'll be a Q&A time at the end as well. So let me make sure I'm also general disclaimer. I am an attorney, but I am not your attorney right now. This webinar is just for general education purposes only. It's not actual legal advice. Not creating an attorney-client relationship by doing this webinar. Just hoping to kind of give you guys an educational moment to help you understand litigation a little bit better. And as always, employment laws vary and change. If you have any specific situation that you're dealing with, reach out to us or another attorney to get advice for your particular situation. General overview of what we're going to be looking at today. General introduction, and then we're going to get into what actually is litigation. That's a phrase or a word that people hear a lot, but a lot of people don't actually know exactly what that means. So we're going to get into that a little bit, and then we're going to get into a more detailed roadmap of what litigation actually looks like, what the timeline is, what you need to know about how the process works. Then prevention and preparation, what you should be doing right now to hopefully avoid lawsuits in the future and prepare yourselves for if you do find yourself in a lawsuit. And then we'll wrap up with a Q&A. So, introduction, why everyone, especially business owners, should understand lawsuits even if you've never faced one and don't anticipate facing one. Bottom line, even if you've never been sued, the potential of a lawsuit should be affecting your day-to-day business because lawsuits don't start with filing a complaint in court. They start with your day-to-day management decisions, your communications, your documentation, all of your day-to-day practices are what, if they're not done right, that's what leads to the lawsuit. So understanding how a lawsuit works, how to prevent a lawsuit now can help you figure out how you're going to run your business, interact with your employees now. So the goal is not to expect litigation, but the goal is to be prepared in case it happens and hopefully prevent litigation. A little bit of background about the kinds of litigation cases that I have been dealing with right now, just to kind of give you an idea of what to be looking for. Most common cases that I deal with are unpaid wages. That includes just regular wages, commissions, stock, your restricted units, stock units, things like that. If those aren't paid properly, they can turn into a lawsuit real fast. Also, post-employment restrictive covenants, including defamation, non-disparagement, non-competes, non-solicitations, Those I typically see more the employer bringing the case against the former employee, but it can go both ways. And then harassment and retaliation. That one doesn't often go to litigation. It's typically dealt with in the more administrative agencies, which I'll explain the difference in a moment. But I actually do have a case or two that has gone beyond the administrative and into litigation. So those are the kinds of issues that I see the most with litigation. So now, what actually is litigation and what is just another legal problem? So start out, what is not litigation? You get a demand letter from an attorney. It feels like legal action because it's got an attorney's law firm stamped on the top of the page. It's not actually litigation. It's just a threat, basically. A demand to change something to prevent further legal action. Administrative complaints. These are claims to the Utah Labor Commission, Department of Workforce Services, the EEOC, Department of Labor, those kinds of administrative agencies run by either the state or the federal agencies. These can feel intense, they can feel like lawsuits, but really they're not. They're just uh, the next few points. They could be investigations, attempts to mediate, audits, things that the agencies are doing to try to figure out what's going on with those claims, but they're not actually litigation. Administrative appeals, these can feel even more like litigation because once a decision is made from those complaints, you have the opportunity to appeal it. That goes before an administrative judge, which is why it feels like a lawsuit because there is a judge. But the rules are completely different than actual litigation. The process is very different. It, um, yeah, not litigation. Still really important to pay attention to these things if they come across your plate. Uh, Treat them like legal issues because they are, but they're not quite as intense as an actual lawsuit. So what is litigation? A lawsuit. You're in state court, you're in federal court, you're before an actual district judge or federal judge. You're filing your pleadings, you're doing your motions, you're preparing for trial, presenting to present your evidence. That is what we're focusing on when we talk about litigation, is those actual in-court lawsuits. So now let's get into the litigation roadmap. What does litigation actually look like? I want to start out by addressing the biggest shock that my clients get when they get into a lawsuit, which is how big of a situation we're actually looking at. This is an example of a scheduling order for one of the cases that I am working on. This is standard kind of middle of the road dollar amount that they're asking for. So it's nothing short and easy, but it's not, millions of dollars going to take forever to deal with. This case was initiated in April of last year. And as you can see from this scheduling order, we're not looking at getting a certificate of readiness for trial. That's not due until July of this year. So more than a year later. And that's not even getting to trial itself. That's just saying we've completed our discovery. We're ready to start preparing for trial. And then trial itself, if it gets to that point, is going to be at least a few months beyond this. So it is the one of the biggest things that I want my clients to understand going into litigation is it is a very long process. This is not Suits or whatever other courtroom dramas that you watch where it's just in and out in a couple weeks. It it's a big process. Process starts with filing a complaint. The complainant, I'm going to phrase this going forward from the perspective of the an employee is suing an employer. That's what I see the most. Obviously, it can go either way. There's a lot of different situations, but just for simplicity, the employee sues the employer. They file a complaint. The com the complaint basically just outlines what happened and why they think they have a legal claim and what that legal claim is. So they the plaintiff has to outline the basis for the legal claim, but it's important to keep in mind that they don't have to present evidence up front. They don't have to go into a lot of detail. Like the bar for having a valid complaint is pretty low. A lot of times, employers, when they get these complaints, they want to come back and say, well, this is wrong, and this is wrong, and this is wrong. So we need to get the whole thing dismissed. And that's great if the things that they say in the complaint are wrong. It the judge isn't interested in a factual dispute at this point. They just want to say, based on what you told me, could there potentially be a valid claim? So then the next step is how are you, as the business owner, the defendant, going to respond? The most common way to respond is by filing an answer. The answer basically just goes through line by line, allegation by allegation. The complaint says this, I admit it, or I deny it. Very straightforward. If there is, if the complaint is too bare-boned or um, doesn't, they allege a certain set of facts that don't support the legal claim that they're trying to make, you can try to get the case dismissed at that point, file a motion to dismiss, or there's a few other types of motions you can file at this early stage, but motion to dismiss is the most common one. So there is some strategy there in how to respond, but again, it's very high level, just focused more on like the legal standard, the legal basis. Is there a claim? Is there not a claim? And then just addressing high level, do you admit the facts alleged in the complaint or do you deny them? And as the attorney, I advise my clients on the best ways to respond, what they should admit to, what they shouldn't admit to. And then it moves forward. Once the answer is on file, then we go into discovery. Discovery is the meat and potatoes of a lawsuit. This is where, looking at that timeline that I showed you a few minutes ago, this is where the vast majority of your time, money, energy is going to be spent, is in discovery. The very first part of discovery is what we call initial disclosures. Initial disclosures, that just means right off the bat, both parties have an obligation to proactively give the other side everything that they have at that point that they think supports their claim or their defense if they're for the employer. So they're disclosing their list of witnesses. They're disclosing the documents and evidence that they relied on in preparing their complaint or their answer. They're disclosing um, anybody who could have information about the case. They have to give up those names. just, and it doesn't, you want it to be as complete as possible, but everyone recognizes that it's the beginning of the case. There's still a lot to uncover. It's probably not going to be a perfect, complete list in production, which is why after the initial disclosures are swapped, then we get into just general fact discovery. That usually starts with discovery requests. Each side will send a written request to the other side asking for specific things that they think the other side might have that would help them either prove or disprove their arguments. Discovery requests come in three main forms. There's requests for admissions, just asking, do you admit this fact? Do you admit this fact? Do you admit this fact? And they respond with either admitting or denying. There's interrogatories, where you just ask an open-ended question or an open-ended request, and they provide a written response to that request. And then finally, is request for productions. These are your documents. These are your physical evidence, emails, text message logs, phone logs, whatever it is that you think will help support your case, you can ask for. This is where I typically see the most action is in these discovery requests. There's a lot of back and forth. I think you have this information. I want these documents from you. Fork them over. And then the other party's doing the same thing, sending requests to you for what they think that they need. An important thing to keep in mind with this is what you actually have to produce. Uh, it can be really easy to say, well, this is unrelated to what their actual claims are, or this document, they don't actually need this document, or this document is highly confidential, we're not going to give it up. Even if it's relevant, we don't want to give it up. Or there's a lot of excuses that business owners will try to come up with for why they don't want to give up their information, which are totally valid from a business perspective. In the case of a lawsuit, there's pretty broad rules about that. Basically, if it is number one, relevant, number two, proportional, you have to produce it. Even if it's going to be totally damning, make you look terrible, you have to produce it if they ask for it. So that it can include emails about the incident at hand, text messages, personnel files that we get a lot of requests for personnel files, your policies, your handbooks, contracts, performance records, wage payment, pay stubs, all of those things, depending on what the claim is, could be relevant to the case. And if they're relevant, you have to produce them. The only exception to if it's relevant is if it's unproportional. So there will be the occasion where the plaintiff might request all of your emails in your entire inbox. That's not proportionate to the case because most of those emails are probably not going to be relevant. It's going to take hours and hours and hours to gather all of that information, sort through it. So there can be objections to proportionality and saying, hey, you need to tone down this request, narrow it down to what you actually need, what's reasonable for us to produce. But if it is something that you can gather up and is reasonable to the case, even if it's in a large number, it needs to be produced. A lot of my clients don't like that, but that is the fact of the matter. So kind of To summarize, you can't cherry pick what evidence you produce. If they ask for it, if it's relevant, if it's not going to break the bank, you know, physically or, break your time bank, what have you, you have to you have to produce it. Another tool for discovery that we see a lot is depositions, which if you've never heard the term before, or if you've heard it but never actually done anything with it, a deposition is basically a formal interview conducted by the attorney of a key witness that is taken under oath, recorded, has all of the legal implications of being in the courtroom testifying. It's just done outside of the courtroom. There's a court reporter rather than the judge, and but the record is kept and it can be used as witness testimony in court if needed, as opposed to just like a informal interview to gather information that is not necessarily under oath or recorded, things like that. So that's the difference between a deposition and just like a regular interview. But depositions can be really useful in getting information from key witnesses, especially if there's something that you feel like they may be holding back through those interrogatories or document production. You can use the deposition as a way to kind of dig deeper and really get all of the facts that you may be limited to through your written discovery. Another tool that can sometimes be helpful depending on the situation is subpoenas. If there's information from third parties that you think is relevant, you can ask the court to send a subpoena to those third parties to produce those documents, and the information, documents, whatever you request from those can be used as evidence as well. All of that is just fact discovery. Once fact discovery ends, then you get into what we call expert discovery. So fact discovery is figuring out the facts of this specific situation. Did it happen? Did it not? All of the particulars around that. After that, you can start bringing in experts. Expert discovery can be really helpful in establishing things like industry standards. If the industry as a whole does something a certain way, that can be a strong defense in if they're saying that, it should have been done a certain way, but it wasn't. You can come back and say, well, actually, this other way is what the industry does, so it's valid. That's one situation that I'm currently using experts for in my cases right now. Another situation for using experts would be medical professionals. If the case is about like an accommodation, an ADA disability accommodation, a medical expert to talk about the employee's conditions can be very valuable. So those are situations where you would want to bring in experts. And the process for gathering information from experts is a little bit different than gathering information from the parties or just random third parties that you might want to issue subpoenas to. If you're relying on these experts for their testimony, we don't need to get into the details because we're, for the sake of time, but there are certain procedures that have to be followed, which is why it comes after fact discovery, has its own time frame. If you think back at that schedule, the time frame for doing expert discovery, it can go up to like 6 months. just because of the technicalities of that whole process for dealing with experts. Discovery is massive. Like I said at the top of this slide, this is where most lawsuits are won or lost, is through the discovery. There's a lot of strategy behind it, a lot of time finding documents, reviewing the documents, interviewing your witnesses, taking depositions. It's a lot of time, it's a lot of money, but when done right, this is where you're going to win your case or lose your case if it's not done right. So, this is probably the biggest point that I want my clients to understand is what discovery entails and why it is so important. And I hope I've made that, I've helped give that clarification a little bit to those of you who are listening. Another big question that employers want to know when they find themselves in a lawsuit is how do we get out of the lawsuit? Nobody wants to be in a lawsuit. Nobody wants to go through that whole year and a half to 2 years or more process, paying tons of money, going through that whole complicated discovery. Like, it's a pain. We want to try to get out of it as soon as we can. So there's a number of different ways for how to end a lawsuit. The ideal is settlement. Settlement, there's two different ways you can reach a settlement. The first, which is the cheapest option, is the two lawyers from either side get together. They've got their clients in the background and they just have informal discussions and come to a meeting point where both parties are happy and both parties agree to just drop it and walk away. That's obviously the cheapest because it doesn't involve any specific processes, doesn't involve bringing other people in. When we can settle through just informal negotiations, we are very happy. That doesn't always happen. And so your next option for trying to settle the case is through mediation. This is where you bring in a neutral third-party mediator who will go between the parties and try to bring them together. This can be a really great option when both sides want to settle, but they just can't bring themselves close enough to a meeting point in the middle. The mediator doesn't represent either side. The mediator doesn't really care about who's right or who's wrong. Their sole purpose is just bringing everyone together to a meeting place. And that is how I see most cases resolved, is through either the informal negotiation or through mediation. That saves you the hassle of taking it all the way to trial. Technically, settlement can happen at any point in the litigation process. I've seen cases, not many, but a couple where, once the complaint is filed, the other side realizes they have no case and they just settle it right off the bat. That's rare, but it does happen. It's a lot more common for it to happen usually near the end of fact discovery, once the parties have a good idea of all of the evidence that they're dealing with and the strengths and the weaknesses of both sides' arguments, then they start thinking, okay, maybe my case isn't as strong as I thought it was, or maybe it is, but I just don't want to deal with it anymore. Maybe it's not going to be, even if I have a strong case that I'm going to win, I'm not going to win enough money to cover my attorney's fees through trial, things like that. And so they go to mediation at that point, end of fact discovery. It's when that usually happens. If settlement, either through negotiation or mediation, is not an option, then the ways to get the case to end is through the court, through the judge, or if it's a jury trial, through the jury. Uh, we talked about dismissal a little bit in how we respond to the complaint. That is a great option when it's available. It doesn't happen a lot. Reasons for getting just a general dismissal is failure to state a claim is the most common one. That's basically the complaint. Even if everything that the complaint says is true, there is no legal claim. Just the facts don't support legal action. Again, it's rare, but I've seen it happen. Other reasons for dismissal that I've seen are jurisdiction. The plaintiff files a lawsuit in one state. There's a contract saying that it has to be filed in another state. You get it dismissed for just filing it in the wrong place. Usually when that happens, they go back and then file it in a different place. Sometimes they just say, meh, not worth my effort, and they let it go. But that is a reason for dismissing the case. If you fail to respond to the complaint, you can get a default judgment, which is basically dismissing for not doing anything. If the plaintiff stops doing anything to try to prosecute the case, that could also be a grounds for dismissal. Another option for the court decisions is summary judgment. This usually happens later on, again, usually after discovery is done, fact discovery is done, and you have all of the evidence that you need. Then it's really common to see motions for summary judgment. What summary judgment is an argument that there is no material dispute in the facts. So both parties agree about what happened. There's no he said, she said about how much wages were owed. There's no everything's documented or everything is admitted. And so if there's no dispute about the facts, there's no real reason to take it to trial. You just say in your written motion, these are the facts. Everyone agrees on the facts. Because these are the facts, I am entitled to this kind of judgment. I see summary judgment more often in your simple cases. It's less common in the more complex cases, simply because the more complex the dispute, the more likely there is that there's going to be facts that the parties disagree about. But when you're in that situation where all of the material facts that you need to prove your claim or to prove your defense are agreed on, there's no dispute in the evidence, it can be a really great way to get a judgment and let me just backtrack. Another important distinction between dismissal and summary judgment is with a dismissal, the case just disappears. Nobody gets anything out of it. But with summary judgment, if the plaintiff wins on summary judgment, there's still, whatever monetary amount or injunctions, declarations, whatever the plaintiff is asking for, they could be issued. Or on the employer side, if the summary judgment is in favor of the defendant, there could be penalties issued against the plaintiff if it's a frivolous claim or the charges dropped. It's a lot more of a substantive outcome as opposed to a dismissal that's just, we're done, we're walking away. And then, of course, there's trial. the part of litigation that everybody thinks is going to happen because that's what we see on TV, but actually in real life very rarely happens. Almost all cases will resolve through one of these other options. The case gets settled, gets dismissed because there's not a claim, summary judgment because there's no disputes about the evidence. Those situations are a lot more common than actually going all the way to trial. But if none of them work, then it goes to trial. This is where you're standing up in front of the judge, you're standing up in front of the jury, you're presenting all of your evidence, making all of your legal arguments, and they make a final decision. We all we all know what trial generally looks like. It's obviously not exactly like what you see in the movies, but I don't think we need to get into too much detail about what that looks like because hopefully you'll never get there. So that's the litigation process in a nutshell. Now, the reason why you're all here probably is how do we avoid that? Number one thing is your risk reduction. So these are all of the other things that our law firm can help you with that happens beforehand. These are making sure you have clear, consistently applied policies, making sure you're classifying your employees the right way so that you're not putting yourself at risk for wage claims, and then paying them the right way too. This is training your managers on what to say or not say, how to discipline their employees, things like that. This is just generally handling discipline and terminations thoughtfully and appropriately. This is knowing when to pick up the phone and call us or whoever your attorney is to address issues as they're starting to get them taken care of before they turn into a lawsuit. The best approach to litigation is preventing it from happening in the first place. Um, how do you prepare? What should you be doing now to prepare just in case your prevention strategies don't work and you find yourself in a lawsuit down the road? Number one thing we always tell our clients is document everything. I probably about half of the lawsuits that I am defending right now could have been prevented by putting things in writing. It's as simple as putting your employment contract in writing, putting your wage, your commissions agreements, putting it in writing. Especially for small businesses, it can be really easy to say, I trust this person, I know them, we've got an oral agreement, we're good. Or this is just the way that it's done, this is the way we've always done it. You assume that that implied agreement based on just how things are always done, that's enough. And when things are going great, that can be enough. But you never know when something is going to go south, when your employee is going to get upset about something, when you accidentally do something wrong. And if you do not have everything documented, that can really hurt you down the road. So please, please put everything in writing, document your employment agreements, document your discipline, your reasons for termination, what have you. Document everything. It'll make everyone's life a lot easier, I promise. And keep on to those documents. Document retention. This one is not as common of a problem, but it's still worth noting. Uh, Keep that employment contract after the employee leaves. You can have a document retention policy that holds on to it for so many years because, statutes of limitations apply and you don't need it forever, but you might need it a year down the road after termination. So make sure you have systems in place to hold on to your documents and not just automatically delete them because you never know when an issue is going to come up that you need to go back and reference it. And then litigation holds. These are so important if you're on the cusp of litigation. This or litigation has even just started. This is where a lawsuit is imminent, a lawsuit is pending. At that point, remember back to our discussion about fact discovery and document production. They can ask for a really broad scope of things. And if you've deleted it, that can cause more issues and in some cases can become a bigger issue than the lawsuit itself because that can get into tampering with evidence or destroying evidence, even if that wasn't your intent. So if keep your documents, but especially if you have a lawsuit that you think is coming or a lawsuit has already been filed, the very first thing you should do is any anybody in the company, issue notices to anybody in the company who could have relevant information and make sure that they are holding on to that. Most the most common situations I see this is don't delete your emails. Don't clear out your OneDrive. Don't, if you've got your text messages sent to auto delete after 30 days, fix that setting. Like those are the kinds of things that you're going to be wanting to do in a litigation hold is change those automatic settings so that those documents are for sure going to be available if needed. And that's litigation in a nutshell. Bottom line, do your preventative measures, prepare yourself now. And if you find yourself in a lawsuit, please come talk to us or talk to another attorney. You're going to have so much peace of mind having an attorney help you navigate it because it is a long, complicated process. There's a lot of strategy. We always want it to be quick and easy. My clients always want to find the fastest way out, but as I often tell my clients, litigation is a game of chess, not checkers. There's a lot of moving pieces. There's a lot of strategy to try to reach the end game that you can't always get right at the beginning. You've got to be thinking multiple steps at a time. It is a lot of time and money, but because it's a lot of time and money, you want to be prepared. So that's about all I have. Do we have any questions?
Okay, if anyone has questions, there's a Q&A feature at the bottom of your screen, but so far, no questions.
Great. I hope that means that I explained it clearly and not that I just left you all stumped.
And if you have questions in the future, of course, people can email us or call the main line as well.
Absolutely. Um, Here's our information if you don't already have it. Please reach out to us if you have any questions. If you find yourself in a sticky situation where you need advice, you think it could lead to litigation, if you've received a summons in the mail saying that you're part of a litigation, give us a call. We would love to help you out.
Okay, one question came in. What if you don't take the administrative EEO processes seriously? Does that have any impact later?
Yes, it can. Um, yeah, so with the administrative processes, one, if you're not taking it seriously, there's a good chance that you could get a determination issued against you. And at that point, once the determination is issued, they're going to give the employee what's called a right to sue letter, which gives them the ability to take it to court and go through this whole big long process that I just walked you through for the past 45 minutes. Um, Dealing with the administrative agency is so much faster, so much easier, so much cheaper than going through litigation. So absolutely take those processes seriously because they're going to save you so much headache if you get a judgment against a determination against you in those and you have to go on to litigation. Yes. Great
Okay.
question.
There's no other questions. We can wrap up in the next 30 seconds or so. Give any other stragglers a few more seconds to finish their questions. But
All
great job,
right.
Kim.
Thank you.
That was very insightful.
I'm glad. And thank you all for coming and listening to me. I know no litigation is not what people want to be thinking about and probably not what you want to be spending your Friday dealing with. So I really appreciate you guys taking the time to learn more about it.
Mhm. Awesome. Thank you so much.
Yeah, thank you.